I'm Hugh Dyer, a director in RSK's Geosciences business. Welcome to the July edition of our 2026 series of Down to Earth webinars. These will cover a broad range of subjects and are available afterwards on our YouTube channel alongside previous talks. Our talk today will be given by Jonathan Pearson from our environmental management team within the Geosciences business. Jonathan will provide an introduction to the discharge of surface water as part of the management of a development site. But firstly, a brief note on housekeeping during the talk. All attendees' microphones are automatically muted through the webinar. During the presentation, you can post questions online and there'll be a Q&A session at the end of the presentation. We'll answer as many questions as possible at the end of the talk. Those that can't be answered due to time constraints will be answered after the webinar. Shortly after the webinar, you will receive a link to a short survey. If you could take a few minutes to provide feedback so that we can improve on our future webinars. Now, please let me introduce our speaker today. Jonathan is a chartered scientist and chartered water and environmental manager with over 15 years experience. Jonathan has extensive experience in environmental management, environmental permitting and management of surface water across a diverse portfolio of projects. Jonathan delivers training to clients on environmental management of sites, as well as supporting clients in managing their construction phase works. I'll hand over now to Jonathan to outline the options available for surface water discharge and potential pitfalls which may be encountered.
Thank you very much for the flattering introduction, Hugh. As suggested, the theme of today's presentation is to highlight the potential mechanisms that are available to manage the discharge of construction surface water that are most commonly encountered by RSK Geosciences, but we'll put a particular focus on bespoke environmental permits. So the key topics that we'll cover today are the primary reasons for why we need to obtain consent to discharge our construction surface water, what options are available with a focus on the three most commonly encountered by RSK Geosciences. We'll go through a bit of a step-by-step guide to permit applications, outlining the key documentation and the key processes that need to be undertaken. And then we'll talk about sort of the conditions and compliance that you need to keep on top of once you've obtained your permit to discharge. So the first key question, why do we need to obtain the consent to discharge our construction surface water? Well, probably most importantly is that it's the law to obtain consent to discharge construction surface water. And ultimately, there's some key regulations and acts that have been put in place to prevent any detrimental impact to the surrounding environment caused by water discharge activities. The primary bit of environmental legislation that covers the discharge of surface water in England and Wales is the Environmental Permitting Regulations 2016, although the potential associated environmental impact caused by pollution is also discussed within the Environmental Protection Act 1990. So ultimately, rainwater-derived surface water runoff and drainage waters from an active construction site is classed by the regulators as a trade effluent, and therefore the activity of its discharge to the environment, either to ground or surface water, will be subject to EPR 2016. One of the most commonly confused aspects associated with site discharge is that people make assumptions that a Section 104 agreement that's been agreed through planning doesn't constitute consent to discharge construction surface water, as ultimately the 104 agreement relates to the completed development, i.e. post-construction. So in terms of EPR, there's two key regulations, so Regulation 12 and Regulation 38, that relate to the discharge of construction surface water. So effectively, Regulation 12 states that effectively people must not discharge or carry out a water discharge activity unless a permit is in place. Regulation 38 is a circular reference to Regulation 12, but there's a second part to Regulation 38 that states that once you have a permit in place, it's against the law to contravene a condition that's written within that environmental permit. And one of the key words that I want to sort of draw your attention to is the word knowingly as well. So knowingly permit can also be interpreted simply as knowing that it's happening. So where some people come unstuck is assuming that, for example, if a client instructs a contractor to carry out all surface water related drainage from their site on their behalf, that sort of gets rid of any responsibility on the client's behalf with regards to the discharge of construction surface water. Knowing that something is happening and doing nothing about it, or trying to pass on the responsibility, will not mean that you're not in breach of EPR. There are separate regulations for Scotland. I won't go into that in too much detail or any further detail in this talk, but historically it was regulated under the Water Environment Regulations 2011, but as of November 2025, it's the Environmental Authorisation Regulations 2018. So what if we don't obtain permit to discharge? Well, ultimately, one of the worst case scenarios is that it could result in criminal prosecution. So on screen are a couple of variable monetary penalties that have been issued to companies where it was determined that there was evidence of negligence or mismanagement and a negative environmental impact as a result. Now, it probably should be noted that the regulator probably won't or may not jump immediately to issuing a variable monetary penalty and may offer advice, guidance and or warnings before jumping straight to fining companies. But as you can see, it's not insignificant amounts of money that are being dished out to people who breach EPR. So advice and guidance, regulators will prefer to support individuals or businesses who've committed an offence or are likely to commit an offence by offering advice and guidance, which may be verbal or written. Any continued breaches or further breaches may influence a later choice of enforcement action. And ultimately, the regulator's objective is to try and provide an opportunity for the operator to return to compliance and stay compliant. Regulators can also issue written warnings if they believe an offence has been committed, and that warning will set out the offence that's been or that they believe has been committed, the actions that the regulator expects to be taken, and what will happen if action is not taken. And ultimately, if advice and guidance and warnings are ignored, then the regulator might go down the route of issuing a variable monetary penalty. How the scale of the fines are determined is based on a number of factors that will include things like company turnover, significance of the harm caused to the environment by the incident, and the culpability of the defendant, or whether the company is a repeat offender. And just on the screen now illustrates or gives an illustration of how fines might potentially be calculated based on company turnover and the level of culpability and the significance of the environmental harm. But I won't touch upon that in too much further detail. An alternate option that the regulator might choose is to go down the route of an enforcement undertaking, which effectively represents a legally binding agreement between the regulator and companies that have breached environmental rules. The regulator generally prefers to choose this route over traditional court prosecution to ensure that localised environmental improvements come as the result of a breach of EPR. And it allows them to bypass lengthy and unpredictable court backlogs and guarantees that the offender takes proactive steps to prevent future incidents. This money effectively helps deliver immediate benefits to the environment without requiring lengthy and uncertain court proceedings, as previously mentioned. On screen, a selection of breaches of EPR. You'll note the majority of them relate to either Regulation 38 Part 1 or Regulation 38 Part 2, i.e. not having a permit in place to discharge, or having a permit in place to discharge and failing to comply with a condition as written within that permit. So we'll talk about three primary options that are available when it comes to construction surface water discharge. The first one we'll very briefly touch upon, RPS 261, or temporary dewatering from excavations to surface water. You may not need an environmental permit if you meet the requirements of this regulatory position statement. Trade effluent consent is required for discharging trade effluent, which can also include certain rainfall related waters from construction sites, and this discharges into foul or combined sewers, and that's obtained from the local water company. So the statutory undertaker, or the relevant statutory undertaker in close proximity to the site where the discharge is taking place. And then, as I say, we'll go into a greater amount of detail on bespoke environmental permits what permissions are required from the regulator to discharge surface water into a watercourse or to ground. It's probably worth noting that consultation may be required with other authorities, including local lead flood authorities or local authorities for flood risk activity permits, land drainage and other consents that may be required when working in or in the vicinity of surface water features, but that won't be discussed in this presentation. So a bit more of an overview on RPS 261. As shown in bold, it relates to discharge of uncontaminated water. So there's an implication there that there will be a level of sampling and testing that needs to be evidenced to prove that the water that's being discharged is uncontaminated. It's generally it is for small scale short-term activities. So there's a time limiting factor of 3 months from the point at which it starts to the point at which the RPS can no longer be utilized. And that 3 months is a consecutive 3 months. So you can't start and stop the RPS as and when your dewatering exercises start and stop. Doesn't change a legal requirement to get a permit, but the EA probably won't take or unlikely to take enforcement action as long as you comply with everything that's written within RPS 261. Ultimately, this slide shows how restrictive it can be. We've already talked, or I've already mentioned the fact that the water needs to be uncontaminated water, and it needs to be clean water. Which could potentially be open to interpretation by the regulator. So on screen in the centre, some bottles of water with different levels of total suspended solids associated with them. So generally what we're seeing with bespoke permit applications, you're looking at about 40 milligrams per litre of total suspended solids, whereas trade effluent consents, you're looking at about 100 milligrams per litre of suspended solids. So the second bottle from the left is 40 milligrams per litre and the middle bottle is 100. So the water really does need to be very, very clear of suspended solids before you can discharge under the RPS. I've already mentioned that it's a continuous 3-month period, but there's other stumbling blocks, including the fact that you'll need to have robust mechanisms in place to limit any water entering an excavation, either from rainfall or from groundwater. You'll have to be able to prove that the discharge from the excavation doesn't include drainage from haul roads or other working areas. So these temporary excavation works really do need to be isolated from other active areas of your construction site. You can't use flocculants or other means to encourage particles to settle out of suspension. You've got restrictive flow rates for discharge, and there's a certain level of sampling that will be required to prove that there's no exceedances of environmental quality standards at any point during the discharge. And the RPS option also isn't available to you if your construction site sits within 500 meters of an environmentally sensitive site. Trade effluent consents generally are promoted by the regulators as the first port of call for discharging your construction surface water. However, it's not always possible, given that throughout the various stages of sort of construction site's life cycle, you may not have access to a foul sewer network. Again, the discharge rates are fairly restrictive, and applications are becoming or being more commonly refused due to a reducing capacity within the foul drainage network. They can be costly because ultimately you'll have to hire pumps and pipe work to be able to discharge to the closest foul sewer available. And generally they're only granted for 12 months and there's no guarantee that a subsequent application will be granted. So ultimately, if you hang your hat on relying on trade effluent consents to discharge your construction surface water and that option gets taken away from you, you'll be scrambling around trying to find an alternative option to utilise going forwards. And again, you'll have to provide evidence of the volume that's being discharged from site, which the statutory undertaker will invoice for. You'll have to carry out sampling and provide analysis to show evidence that the discharge remains compliant with conditions associated with things like pH, level of TSS, and site-specific contaminants. So as mentioned earlier, we'll go through a bit of a step-by-step guide now to sort of bespoke environmental permit applications. And one of the key points to highlight is that it's really important that you understand the permitting process and that you conduct thorough preparation before submitting a permit application. because ultimately this will lead to smooth project delivery and overall regulatory compliance. The key steps associated with an environmental permit application are shown on screen, and we'll go through each of them one by one, from pre-application advice through to submitting the correct forms and associated documentation, and we'll touch upon the timescales associated with the application process as well. So pre-application advice is something that's offered by the regulators, although I would state that it is non-mandatory, and it works best when you've prepared clear, concise questions which will help define the scope of works, including confirmation of the type of permit required, the supporting information needed to support the application, and confirmation of the charges to be paid as part of the application process. It comes in two forms. You've got basic advice, which is a free service provided by the regulators, and this offers guidance on the type of permit, relevant application forms, applicable charges, and general risk assessment needs. Basic advice is most suitable for straightforward projects or when you need initial direction on the permitting process. Enhanced advice is a more detailed chargeable service, which the regulators currently charge at £103.80 plus VAT. And this will provide in-depth site-specific guidance, with most requests being completed in 10 hours or less. Generally, the regulator will contact you to agree a maximum cost. And involved in enhanced pre-app, this may include one-to-one meetings with regulators, tailored feedback on the proposed activities, and a bit more guidance and help with regards to complex or unusual scenarios. There's 4 main application forms that need to be submitted as part of a bespoke environmental permit application for the discharge of construction surface water. Part A, which is all about you, who it is that's submitting the application. Part B is about the permit. B2. Part B6 gives a bit more detail on the activities that's taking place, and Part F1 highlights the charges and the declarations. For the Environment Agency, these are PDF forms that you download and fill out, so it's really important that you're double checking that you're using the latest versions. These do get updated semi-regularly, but for NRW, so Natural Resources Wales, the application is completed online, and we'll touch upon each of these forms in a bit more detail now. So Part A captures essential applicant and site details, which will include contact and billing information, and it's a mandatory requirement for all new bespoke permit applications. It ensures that accurate and complete information is utilised, and that will facilitate the successful processing of the application. Part B2 covers general details about the proposed activities, which will include details for the installation or the activities taking place, in this case, a water discharge activity when it relates to construction surface water and the discharge of. You'll have to provide national grid references for the site, for any discharge points, monitoring points, and sampling points that will be adhered to throughout the life cycle of the construction site. Details and references of supporting information and documents that are provided in support of the application, which I'll touch upon in a bit more detail later on. But this will generally include a construction surface water management plan, a permit supporting statement, including non-technical summary, relevant risk assessments, and the environmental management systems that the operator will utilise to identify and reduce the risk of pollution from the construction site. Part B6 goes into a bit more detail about the water discharge or groundwater discharge activities, although it should be noted that a fair few sections of this form relate to the discharge of foul sewage and typically don't need to be completed for the discharge of construction surface water. There is quite a handy table, so table 1 within form B6, which confirms the questions that you're required to answer depending on the type of effluent that you're looking to discharge. But ultimately, the form covers the description of the discharge activity, the anticipated timescales that the activity will be taking place, what volumes are to be discharged and the rate at which they will be discharged. It touches upon whether the site's within a nutrient neutral catchment area, whether there's any treatment that's likely to be involved on the effluent, so passive or chemical treatment, whether they'll be required, whether it's likely that the discharge will contain any specific substances listed within relevant guidance documents, and it makes reference to environmental risk assessments and modelling that have been carried out as part of the application process. And I mentioned earlier, but it's probably worth noting again that EA guidance states that ideally you would discharge your wastewater to public foul or combined sewer whenever it's reasonable to do so. So ultimately, this would link back to potentially obtaining a trade effluents license, unless you can provide sufficient evidence that your wastewater cannot be discharged into an existing foul network. So that would have to be supplied as part of your B6 form. And finally, part F1, this covers all charges and declarations, including payment details and applicant confirmation. Ultimately, whoever is submitting the application will be responsible for confirming that all financial and legal obligations associated with the permit are met. So this section needs to be signed and submitted either by a named director or secretary on Companies House, or by someone who's been authorised via a power of attorney letter to submit applications on behalf of the company, as ultimately the named person accepts responsibility for compliance when the permit's issued. Current charges associated with an EA permit application are shown on the screen now. So it's currently £8,126.99 for a new permit application to discharge your construction surface water. But also shown on screen are some fees for a small selection of more common assessments that the regulator may determine are required as part of the permit application. Supporting documentation forms a critical part of any permit application, and where possible, we try and encapsulate this into 1 or 2 reports that accompany the application forms. Typical requirements, in addition to a description of the proposed discharge activity, include but aren't necessarily limited to detailed site plans, non-technical summaries, EMS documentation, construction surface water management plan, risk assessments, flood risk assessments, and records of any consultations done. And I'll touch upon the 2 key documents that RSK Geosciences tend to help with in the next couple of slides. So construction surface water management plan is one of the key documents and will be discussed in greater detail in a down-to-earth webinar later on in the year. However, ultimately, this construction surface water management plan presents a strategy for how we're going to manage surface water and silt related risks, and also establishes the general principles of surface water and silt management that will be implemented consistently throughout the life cycle of a development. It's one of the most crucial documents submitted as part of the application, and should include a risk rating derived from site-specific information, including the proximity to sensitive receptors, the geology beneath the site, what the topography of the site looks like, the flood risks at the site, and any development constraints. The surface water management plan should also include a schematic that highlights the drainage proposals for the scheme, the location of any key mitigation measures that are being put in place, and the key monitoring and sampling points on the site. And these plans are designed to be printed out at A1, stuck on a site notice board so that everyone knows what they need to adhere to. The construction surface water management plan facilitates the effective communication, the expectations and requirements for the implementation of appropriate control measures, and the necessary monitoring regime to reduce the likelihood of an environmental pollution incident occurring to surface waters. The construction surface water management plan, where possible, we try and promote cost-effective sustainable solutions that will reduce the degradation of land and water from uncontrolled erosion and sedimentation. And they're intended to be a live document that should be continually reviewed and updated at key stages of the development process. I've just put up on screen a selection of some of the options that are available when it comes to construction surface water management. So you've got silt fencing top left, drainage capture channels with stone check dams, middle picture, and gabion baskets fitted tightly within outfall wing walls. But again, this will be discussed in more detail in a later down-to-earth webinar. So the next key document is a robust risk assessment, which is vital for demonstrating that proposed discharges will not cause harm to the environment. So taking surface water risk assessment, ultimately these must consider the quality and the quantity of the discharge, the characteristics of the receiving watercourse, and any potential pollutants that might be discharged from your construction site. So key data requirements encapsulated within surface water risk assessment include things like baseline water quality, discharge rates, and contaminant concentrations. It's a 3-stage screening test that's applied to determine the presence of hazardous substances, and predicted impacts are compared to the relevant environmental quality standards. Other considerations that get taken into account within surface water risk assessments are things like the dilution potential of the water course and background concentrations. It is possible that a greater level of surface water risk assessment might be required, so a full H1 environmental risk assessment, but this is likely to be primarily on contaminated or brownfield sites, or those sites that sit within 500 metres of a designated environmentally sensitive site. Groundwater risk assessments ultimately will require a conceptual model of the site, again, which identifies your key sources, the key pathways, and the key receptors. And this process will involve qualitative and quantitative risk assessments with more detailed analysis where sites are sat on more sensitive aquifers. And ultimately, the key output of the risk assessment is to demonstrate that hazardous substances are prevented from entering groundwater and that non-hazardous pollutants are controlled to avoid pollution. So in terms of application submission, on screen are sort of the key stages that are highlighted associated with the application timeline and the points at which RFIs may be issued and the key durations of each step. So ultimately, the first step is once you've got all of your relevant documentation together, the application gets submitted either to the EA via email with a designated OneDrive location or provided online to NRW, and we'll get an acknowledgement email relatively quickly saying we've received your application and the initial administrative or validation checks are being commenced. Once the administrative validation checks are made, further information may be requested by request for information or RFI process. And generally, RFIs are designed to rectify minor errors. So if there's a missing fee or there's a missing form or something's been sort of not completed correctly, then this might come in as an RFI, or it might be that additional clarity is required on minor points. The key point being that it's not designed to address significant emissions from the application. So if there's no supporting chemical analysis or anything else that's key to the application that might be missing. So because it's designed to rectify minor errors, there's relatively strict time conditions imposed on us when it comes to responding to RFIs, and generally they're required within 5 working days. If we don't reply within the allotted time, then this will lead to the application being returned, and 10% of the application fee that's being paid by the client will be retained by the regulator. Once the initial RFI process is complete, the application is then passed to a queue for a permitting officer to pick up and reviewed for duly making checks. Once the application is duly made, we're looking at anywhere between 3 and 8 months on current timescales, and that is when the application will be determined. And ultimately, the permit is either approved and issued once the relevant legal checks are complete, or the application gets refused. Probably something that's really important to highlight is ultimately we have no control over the length of time that this process takes, and we're actively discouraged by the regulators from chasing updates on applications. So we don't have any sort of access to anyone who can provide updates on applications. Once the applications are submitted to the regulator, they need to be left alone to determine the application accordingly, because having to respond to chasing emails is having a negative impact on their ability to turn around applications in a timely fashion. So once you have the permit, we need to make sure that we adopt a stance that facilitates ongoing compliance, and it's important to understand what conditions are within our permits and make sure this is communicated to all members of site teams, because ultimately these are the discharge limits and the monitoring requirements associated with the permit that allow us to stay compliant. So in terms of discharge limits and monitoring requirements, the permit will have limits for things like the volume of water and the quality of water to be discharged. So I mentioned suspended solids earlier at 40 milligrams per litre, so very clean water. But there'll also be information in there on the pH of the water, visible oils and greases, and this might need to be evidenced through both on-site and lab testing to demonstrate overall compliance with your permit once you have it. So ultimately, operators or holders of the permit must maintain detailed records of the monitoring that's been undertaken, or site inspections that have been done, and whether any incidents have taken place. And when there are issues associated with non-compliance or incidents that take place, if you've got a condition that's breached, immediate action is required to make sure that you get back to within or below the limits that are stated within your permit and contain any pollution. But probably most importantly is to investigate the cause and to try and prevent it from happening in the future. And that brings me to the end, so the summary. So ultimately, probably the key reasons of why we need to obtain consent to discharge our construction surface water is because there can be an impact, or there is an impact to the environment associated with illegal discharges, but also there's an impact to businesses associated with any prosecutions or enforcement undertakings that are handed out. But also there's likely to be a negative impact on reputation with customers and national and local stakeholders. There are a few options that are available. So I briefly discussed the regulatory position statement 261 and trade effluent consents, but yeah, it went into a bit more detail with regards to a bespoke permit or bespoke environmental permit application. It's really important that you understand the permitting process and that you're thoroughly prepared before submitting a permit application, because that will ultimately lead to smooth project delivery and regulatory compliance. And once you have your permit in place, you need to make sure that you stay compliant, or if there are any breaches, that you return to compliance as soon as possible. Thank you for listening, and I'm happy to take any questions.
Thank you, Jonathan. That was really interesting. Certainly a few points in there that I've learned today. We've got a number of questions that are coming in now. So if you're happy, I'll start with where does the responsibility sit between a developer and a contractor on site?
So generally, it would be a developer. If you're going down the route of a bespoke permit application, then it would be the developer who is submitting the application. So liability would sit with them. Although what I would say is there are incidents that have taken place historically where both contractors and developers or landowners have been prosecuted for the same incident. They might be prosecuted under different regulations, but ultimately it's a site-wide thing. Everyone is responsible for ensuring that discharges to the environment don't cause any sort of environmental impact. So what I would say is that don't assume that someone else is ensuring that you are compliant. Take ownership, whether you're a contractor, whether you're a developer or a landowner. And everyone needs to be working together to ensure compliance with whichever mechanism it is that you decide that you're going to utilize on your construction sites.
Right. Okay. No, that's really helpful. What happens if there's a significant rainfall event and where this overwhelms the precautions on site and causes a pollution event or exceeds the discharge volume?
I think it's accepted by the regulators that these sorts of incidents happen. And on the slide earlier, when I was talking about levels of culpability, there is a level of culpability in there that is low or no culpability. And that does specifically mention exceptional weather events, along with things like actions of rogue employees, effectively things that you can't potentially foresee happening. Now, I guess extreme events or what would have been considered extreme events sort of maybe 10 years ago aren't necessarily considered extreme events these days. So I would suggest exercising caution when talking about exceptional events. But ultimately, yeah, if you can demonstrate that there is a low level or no culpability associated with what has happened, then then yeah, there's not really a huge amount that you can do about it. Although what I would say is that if you have an effective construction surface water management plan in place, and you've been monitoring, I don't know, levels of water in your attenuation basins, or you've got provisions for temporary settlement ponds, and that you've implemented everything that you can as outlined within a surface water management plan for the site, then hopefully, even in exceptional circumstances, you won't breach any conditions that are associated with a permit that you've got in place, for example.
Okay, that's really good. That's useful. Someone's asked, can you use the RPS 261 consent on a site more than once during the duration of a project or for different phases? And then is there a timescale between those applications or the way you use it?
Yes, you can use RPS 261 more than once, but what I would say is it can't be for the same activity in the same area of site. So if you're proposing to temporarily dewater an excavation, and that single excavation takes longer than 3 months to dewater, you can't then submit another, or you can't then state that you'll be utilizing RPS 261 for the same excavation. So that's really where record keeping comes in. Extremely handy if you've got notes of when you started the dewatering, when you completed the dewatering. Then obviously you'll be able to provide that to the regulator to demonstrate compliance with the RPS. But you can use it more than once. So if you're dewatering multiple excavations in multiple different places on your construction site, then yes, you can utilize it more than once. I would have to double check if there's any time limiting factors. I don't think there are with regards to utilizing the RPS sort of finishing on a Friday and starting again on a Monday. But yes, it would have to be for a different dewatering activity that's taking place in a different part of your site.
Right. Okay. No, that's good. Is a surface water risk assessment always required to support the discharge consent? If it can be shown that the treatment system removes all anticipated contaminants, would further testing and risk assessment be required?
Sorry, can you just repeat that?
So would you have to do a surface water risk assessment to support the discharge consent?
I think ultimately our experience is that a surface water risk assessment forms one of the key documents to achieve a successful bespoke permit application. So I would say that there must be some level of surface water risk assessment. It might not be formally written as this is a surface water risk assessment, but I would say that there would have to be some assessment of risk associated with the discharge or the discharge activity that you're looking to adopt on your construction site to be able to satisfy the regulators that you'll stay compliant with any conditions that are written within any permit application. I hope that answers the question. I'm not sure whether it does or not.
Yeah, I think that the second part was then, do you need to do the compliance testing of the discharged water?
Yeah, so it is a mandatory requirement. Once an application has been approved or has been granted, you have to be able to demonstrate evidence of compliance. So if a regulator turned up on site and asked you to evidence how you were staying compliant with your permit, and you had no documentation to show them, then ultimately you can't prove that you are. So yeah, that as a minimum should be some form of on-site monitoring and testing. But I would suggest that that would also need to be supplemented with lab testing and lab analysis that you can provide to the regulator as and when they come to ask for it.
Okay. I think just a couple more questions before I use up all your brain power. For a site that has a private network within, say, a large site, but discharges then to the local water company network, would you have to do a discharge consent for each manhole across the site, or would it just be at the ultimate outfall of that private network into the public sewer?
So we're talking about discharging into a manhole on site that ultimately then travels a certain distance before outfalling into. Is that what we?
Yes, yeah. So
Yeah, so I
it,
would say that, yeah, ultimately, yeah, you would all of that would be outlined within the application that gets. I'm assuming we're talking trade effluent consent because we're talking about discharge into sewage networks. But ultimately, yeah, whichever mechanism it is that you utilise to sort of discharge your construction surface water, the compliance point, i.e., the point at which you need to be compliant, would be specified within that documentation. So
so it
yeah,
would be to the ultimate outfall point,
I
either to
believe so.
public
Yeah,
sewer or
yeah,
to watercourse.
yeah.
Okay. And then you talked about discharge to groundwater and groundwater risk assessments.
Yeah.
Would you need an environmental permit for rainwater discharging into the ground? So this is, I'm assuming, where it's percolating into the ground.
Yeah, so if you're adopting sort of infiltration drainage rather than attenuation and ultimate discharge from a head wall. So
Yeah.
yeah, the discharge of any construction surface water, whether it's from a head wall or discharge to ground, would need a permit to successfully discharge and to be compliant with the relevant regulations. So yeah, whether you're discharging to ground or whether you're discharging to surface water, there should be a bespoke environmental permit in place if that's the option that you're choosing to utilise.
But I'm assuming this is where you're collecting water from a on-site system and then discharging to groundwater rather than just it's falling on your site and then ultimately percolating through the ground into the groundwater.
Okay, it might be one that I have to take away and yeah,
Yeah.
have a look at because I think there's probably a fair few intricacies that you'd need to look into with regards to what
How that,
actually is happening on place and how that's being discharged.
yes, yeah, no, that's good. I think we'll stop the questions there. We have had a lot of questions coming in and some really interesting questions coming in there. So Jonathan will, once he's recovered some brain power, then answer those questions and get back to you. We're taking so thank you ever so much, Jonathan, for the presentation and answering the questions. That's been really, really interesting today. We're taking a break for the summer, and our next Down to Earth talk will be on Tuesday, the 15th of September, and we'll be discussing the potential use and limitation of incinerator bottom ash aggregate. So please remember to complete the feedback following the presentation. Thank you for attending today, and we'll see you again in September.